joining us for this session. Before we get the session underway, we have a short video from the Lord Chancellor and Secretary of State, Alex Chalk.
When I heard from Lord Swire that I'd been invited to the Commonwealth Trade and Investment Summit, I was so excited about coming along. I've been looking forward to it for a long time, and I'm so disappointed that now that something has come up at the last minute, which means I can't join you. But thank you to Lord Swire for his role in organising and inviting me. And the good news for you is that you've got Lord Bellamy coming along, who is eminently qualified in this area from his role as a mediator and arbitrator in the past. So have a wonderful day. I just wanted to add this, if I may. The common law and the international rules-based order is absolutely at the heart of what knits us together as a group of nations. And the reason, of course, as you know why it's so important, is yes, it has its roots in history, but it is relentlessly modern. It has that unique ability to adapt and adjust to the circumstances of the day. And I know from going around the world just how important it is for the wealth of our nations, for trade, but also this, for the international rules-based order. All of your countries help contribute to it. The common law gives us the tools to do it, and I'm delighted to see it being strengthened at your conference today. So thank you for coming along. I'm so sorry I can't be with you. I know you'll have a wonderful day. Thank you.
Well, thank you to the Lord Chancellor, and he's absolutely right. He has sent in his stead someone even more qualified than him to talk about the matters that are of interest us today, namely Lord Bellamy, my colleague in the House of Lords. The Minister has the invidious task of answering for all legal matters in the House of Lords, from prisons to, everything you can think of. So he's extremely busy. So we're extremely fortunate not only to have him here with us today, but also given his own past life before he became a politician, where he was a very senior KC, originally QC, and judge, and involved in all kinds of commercial arbitration and so forth. And we're very fortunate to be able to pick his brains here this morning. So, without further ado, can I just kick off by saying the Commonwealth Legal Network is our organisation. It's the hypothecated part of the Commonwealth Enterprise Investment Council, and we're seeking to establish a network of legal firms across the Commonwealth who can refer our other strategic partners and do business in all these jurisdictions and navigate their way through these quite difficult legislative and other issues that they face when they're investing. But to what extent does the legal sector have a role to play in facilitating international trade, and how can Commonwealth nations work better together to actually tackle all the barriers to trade that they're still encountering?
Well, Hugo, thank you very much for that question, and good morning, everyone. And I'm absolutely delighted to be here. And as you've heard from Alex Chalk, he's very sorry that he can't be with you, but he's sent me instead, and you'll have to put up with me, I'm afraid. As regards the main question, what role do legal services play in facilitating international trade? The answer is, I think that international trade couldn't really happen at all without legal services. Every investment needs a contract. Every contract needs a mechanism for solving disputes. Every investor needs to know that their contract will be enforceable. So without these means, the trade and investment doesn't really get off the ground, which is why I think, to come to the second half of your question, in particular in relation to the Commonwealth Legal Network and other mechanisms, if I may say so, as members of the Commonwealth, we all do have a head start because we share, broadly speaking, the common law legal system, which accounts just within the Commonwealth for about a quarter of the world's the jurisdictions. If you add in the United States, which is also a common law country, which is eligible to join the Commonwealth but hasn't quite got round to doing so quite yet, the legal world to which we collectively belong is by far and away the dominant world for investment, trade, and commerce. And I think we're also particularly lucky to now have the advantage to tap into the civil law tradition of some of our newer members, particularly our colleagues from Africa, who come into the Commonwealth with a different legal tradition. So we're probably going to enjoy the best of both worlds. But with that background, if we can coordinate and facilitate interchanges and developments on the legal front, I would say we're extremely well placed. To give one or two examples, the UK and Singapore work very closely together, particularly on law tech. The UK-Australia agreement has some quite innovative provisions about developing legal services and understanding where barriers to trade are. India is a very good example of a nation that's opening up the legal sector, realizing that's a very important step from the Indian perspective. We work closely with Nigeria, and there are many other examples. So I think, if I may say so, there's all to play for in this sector.
Just one point which we discussed previously, which is the changing face of the Commonwealth.
Yes.
So the Commonwealth came out, if you like, out of the dying embers of the British Empire post-war. It was the British Commonwealth and so forth, and based on British common law and all that. The Commonwealth today is a very, very different organisation. You only have to look at the most recent countries to accede to the Commonwealth, namely Mozambique, Rwanda, Cameroon, all these other countries which have joined, which don't have a tradition or don't have a connection with the UK or common law. And if you look at the list of other countries who aspire to join the Commonwealth, and I always think the way you judge a club is the members of the club and the list of the people who want to join the club, and it's astonishing the countries that come to us and say, how do we join the Commonwealth? And that's obviously not what we do, but I mean, it's going to take us further away from the founding, the start of the Commonwealth. So how do you say we pick the best of both systems? Is there a mechanism for? Do you think some of those laws which are based on French law, for instance, will be incorporated in some way, or do you think commercial law and dispute resolution and so forth within the Commonwealth will largely stay based on existing common law?
Well, I think I'd answer in this way, and just for background, at one stage in my career I did a stint as a judge in Europe, where again you're working with two different jurisdictions, civil law and the common law together. And the interesting thing I found was that the end solution is very much the same in whatever jurisdiction you're in. The route by which you get there is often quite different. The way you think about things is quite different, but the end result is the same. So I would say, I think, for the foreseeable future, the commercial and international status of the common law, particularly in certain sectors like insurance, like marine, like shipping, etc., is so entrenched it'll take a while before there'll be a significant civil law input. But I think we can really profit, if I may say so, through dialogue between the various jurisdictions to draw the best of both worlds. And when I think the UK has, in its position, been able to learn a lot from other jurisdictions, either common law or civil.
And in your opinion, what value does upholding the rule of law bring to the UK and the Commonwealth in a wider sense, in promoting free trade and facilitating economic growth, maintaining the UK's international reputation and so forth?
Well, I would say that the rule of law is absolutely fundamental here. Because, as I said a moment ago, an investor needs to know that he's going to get his money back. It's as simple as that. That the obligations are going to be enforced, that the courts that decide any dispute are impartial, that the judges are independent, that they will give a fair hearing. And I've worked in a number of Commonwealth countries over the years, in Africa, in Asia, and elsewhere, Australasia. But I remember particularly one conversation with a Chief Justice in an African country who said to me, you know, I know that investment in my country depends on me. I'm the Chief Justice, and people have got to know that if there is a dispute that comes before my court, then I will uphold the law, whether it's in my country's interest or not. And I think he was absolutely right. And that was a good example of the deep truth that you need the rule of law to build economic development, to build social development, to create investment, to raise standard of living, and to live harmoniously and successfully side by side.
So the Secretariat had an attempt when I was involved in producing the Commonwealth Charter, which everyone signed up to, which was quite difficult for some countries at different speeds in the Commonwealth. But the one thing it did do, it was very clear about supporting an independent, impartial, honest and competent judiciary. So what is needed from governments to reinforce the independence of that judiciary and to prevent it being threatened and influenced politically? And I think you've just been at a conference for a whole lot of Commonwealth legal ministers.
I had the great pleasure of attending the Commonwealth Judges Association conference a couple of months ago in Cardiff in South Wales, where we had 400 judges from the Commonwealth, and we were discussing many topics, including the rule of law. I'll just say a short word about that, because the rule of law is a sort of phrase that people sort of speak, and it sounds warm and friendly and all the rest of it. People are not always very clear exactly what we mean by the rule of law. And I think what I mean about the rule of law is the understanding, or the concept and the basic principle that the government will obey the court and will obey the statutes which the government, is subject to. And it's quite interesting. This is a little, I did actually mention this when I was down in Cardiff giving a speech. In the chamber where Hugo Swire and I work daily, in the Parliament chamber, up on the wall at one end, there's a fresco. And it shows a scene several hundred years ago. It's actually taken from a Shakespeare play, but it shows a scene several hundred years ago. And in it, there's a king of England, or a king, shall we say, and he's kneeling in front of the Chief Justice. And that, as it were, symbolizes, in my view at least, the concept of the rule of law, that the king, or in modern terms, the government, will accept the ruling of the courts. And in order to get to that position, what the governments need to do, which is what Hugo's question is, what do they need to do? They need to exercise very significant self-restraint. They need to, and we need collectively, to grow and reinforce a culture whereby governments do accept that they have to obey the legal framework in which they exist, that it's in the interests of governments to do so. It's in the interests in the long run of the community to do so, because it'll bring in investment, and that this is a feature that will lead ultimately to greater prosperity and greater contentment in the body politic, which is why I think the rule of law is so crucial. And one element of it, just to finish on your question, one particular element of it is to ensure that your judiciary has security of tenure. That is to say, they can't be sacked at whim, as it were, by a government that doesn't like the decisions. In this country, just anecdotally, our judges are paid out of what's called the Consolidated Fund, which is another part of the Treasury mechanism, which means you can't cut the judges' salaries, for example. You can't put pressure on a judge by reducing his take-home pay. That's just a small example. But the independence of the judiciary, in the end, is something we all have to fight for, and it's not necessarily easy everywhere in the world, that I absolutely know. But I think collectively we can bring a lot of moral and practical pressure to bear to uphold this fundamental principle.
I mean, I agree. I always used to say about attracting inward investment to the UK, the one thing that long-term investors or any investor is looking for is economic certainty, as much as you can guarantee that, predictability, so they're not going to have their assets sequestered, nationalised or seized from them, and critically, above all that, the rule of law, a politically uninfluenced judiciary which is independent of the politicians. And once you've got those in place, it's a pretty good environment in which to invest. But with that in mind, and we are not really about extending Commonwealth law across the Commonwealth, because we are more keen on the commercial aspect of it, but I'd just like to ask you, do you think there's and maybe this is being done, but is there a greater role for these new countries coming in to the Commonwealth to be made more familiar with our laws and with common laws rather than civil law? Is there an ongoing process by which judges and lawyers from these newer Commonwealth countries are immersed in common law, or is that rather condescending? Would they know about it anyway?
I think there is enormous potential for much more dialogue between the various legal systems of the world, particularly the civil law system essentially descended from the Code Napoleon and similar origins, and the common law world. And as I said a moment ago, when I was working in Europe, it was absolutely fascinating and I think mutually enriching for everybody to learn from each other about the way you tackle particular points. And I learned a lot, and I wouldn't by any means try to suggest that one system is in some sense superior to another in terms of value. So I do think, Hugo, if I may say so, in the context of this organisation that sponsors this conference and other Commonwealth organisations, it would be important to foster a dialogue between countries with slightly different legal traditions. It's not the first time we've had we've got Quebec, we've got Sri Lanka, we've got South Africa. They've all got various different legal traditions, apart from our newer members who may be primarily using a civil code approach. There's a huge advantage, I think, in that dialogue to learn from each other.
It's a very short session, this, and I just can't let you leave without talking about the issue of the moment. The Prime Minister, Rishi Sunak, hosted a very successful AI conference recently, and one hears all kinds of both encouraging stories about AI and very concerning stories about AI. In fact, there's an awful lot of anecdotally groundwork that legal cases can do from AI now, and is that going to put a lot of solicitors and barristers out of a job? That remains to be seen. But to your way of thinking, as you know, we are all Commonwealth countries trying to do business, trying to keep ahead of the curve, is AI some kind of existential threat, or is it something we can harness so as to make ourselves more efficient and get business done in a quicker, more transparent and coherent way?
Well, I would say the latter. This is going to be a new opportunity that in some ways we badly need in some parts of the legal system, particularly in very large commercial disputes, which these days can generate 1 million documents, or 1 million or 2 documents. You've got to have some technique for being able to work through it. It's almost impossible for the human brain, at least a single judge, to take it all on board. So we do need techniques. And we're supposed to live in a paperless world, but the paperless world seems to have generated much more paper than ever before, somehow or other. A typical unexpected consequence. But I think again, and this is basically the message from Bletchley, the Bletchley conference, which was the AI summit, 50 countries, US, EU, very many leading Commonwealth jurisdictions, et cetera, more or less the whole world, signed up to the Bletchley Declaration, which basically says, look, there are some risks here. AI can be manipulated, can be distorted, it can just be wrong, frankly. So you've got to be very careful as we develop it. But on the other hand, there are all kinds of tasks that can be more efficiently and quickly and more cheaply done through an AI, through AI mechanisms than they can be by the human hand, as it were. So it's very early days yet. We have an AI regulator in this country who's working through it. The UK government, since 2019, has sponsored a law tech initiative through Law Tech UK. We're tackling these things one by one. We're going to have to strike a balance. I don't think in the long run it's going to threaten jobs or it may change jobs a bit, but I don't think you're ever going to be able to remove the human factor, and that factor which, from a legal perspective, is above all the most important, which is judgment. How you actually arrive at a judgment as to how to look at particular facts or how to balance particular issues and how to come down on one side or the other. That's a human quality that I think we're never going to be able to do without. But there's quite a lot of groundwork in terms of the legal landscape that can be made more accessible, especially to smaller businesses, through the use of AI. So it's a mixed picture, but I would say there's all to play for.
And one of the things we always hear about is the logjam in the courts and
Yes.
getting your case heard, and it can take forever. In theory, AI should speed that up?
In theory, AI should speed that up. I think we're a long way from mastering the necessary techniques that would enable it to speed up, but we can probably develop mechanisms that will perhaps to a large extent reduce the need to go to court in the first place, because a lot of court cases and other disputes can depend on misunderstandings or misappreciations of what the law is. So I think there's a scope for reducing the workload of the courts, and indeed for speeding up court processes once the court.
So what you're saying is actually commercial disputes, the way they're actually handled, could change. And you could see far fewer of them actually being escalated up to a court level.
You might see fewer of them, but those that do need to be adjudicated upon, and many will need to be adjudicated upon, I think can probably be adjudicated upon over time more efficiently. And we may see that particularly, and I should have mentioned this a little bit earlier, we've been concentrating on legal systems, but let's not forget the vast scope for alternative dispute resolution through the arbitration process, through mediation, through other means of resolving disputes. Singapore and the Commonwealth is a great centre for that. We're going toe-to-toe with Singapore here in London as to who is really the best. We're certainly joint first at the moment. But there is a huge area there where people can also solve their disputes through the very great strengths that arbitration and similar mechanisms have in the common law world, which is another advantage for the Commonwealth.
Well, you've just given me a good idea. I think we might have a CLN session on AI and the implications going forward. I think that would be of interest to everyone. Minister, I'm conscious that your officials want to get you away to your next meeting, and you've been extremely kind to come for this session. I'm sorry it's so short, but would you like to add anything to what you've already said about the Commonwealth, doing business in the Commonwealth, your view of the Commonwealth as a marketplace of 56 countries, some of which have the fastest growing economies in the world?
My own view is that the Commonwealth and the countries in the Commonwealth are absolutely central to the stability and progress of the world going forward. We now, as Hugo Swire said at the beginning, Commonwealth is completely transformed from what it was 50 years ago or whatever it is. It's now dynamic, forward-looking, modern, consists of countries that have very high growth rates, are very important, are increasingly important, and therefore I'm extremely proud to be able to speak to you today. And I very much hope the Commonwealth, I'm sure the Commonwealth will rise to its destiny, or the countries within the Commonwealth will rise to their destiny and be a major force for good in the world going forward.
Well, thank you very much. And for our part, we reserve the right to approach your office again to try and get you to do another session with us, perhaps a longer session, perhaps online in the future. You've been extremely kind to share your views with us this morning. Thank you. I'm afraid we're going to have to change sessions now, and I'm a stickler for time, and I think I'm not doing too badly. I'm sorry that we haven't got time to take any questions, because I'm sure there are a lot of questions you would like to ask the Minister, but that will have to be for another time. But in the meantime, I hope you will join me in thanking the Minister, Lord Bellamy, for joining us here at this session this morning. Thank you very much indeed.
Thank you.
Thank you.